Welcome back everyone for session 2 of day 1 of the 10th Asia Pacific ADR Virtual Conference. Our second session invites an exciting discussion on the changes and proposals for better practices in international arbitration and challenging conventions and customs in arbitration practice. This session will be moderated by Mr. Kevin Kapu Kim. Mr. Kim is a senior partner at Peter & Kim, having previously been a senior partner at Bay Kim & Lee, as a co-founder and head of the International Arbitration Practice and International Disputes Group. We are also proud to say that Mr. Kim is the chairman of KCAB International's International Arbitration Committee. Mr. Kim will be joined by partners from globally recognized law firms, and we are excited to have them gathered for an insightful discussion. So I pass the screen over now to Mr. Kim.
Thank you. It's my great pleasure to moderate this session. As this session, we are talking about the proposals of the better practice. So we have the panelists for this session. So let me introduce briefly the panelists. Actually, I can spend whole day to introduce the whole session to introduce these members because I know them very well. But just very briefly, the first panelist I would like to introduce is Miss Una Jo. My frequent opposing counsel, but we sometimes work together. And she's a partner at the International Arbitration and Cross-Border Litigation Practice at Kim & Chang. She actually majored psychology and communication and then become a lawyer. Naturally, very formidable lawyer and very persuasive, very precise. Una actually worked at the White & Case in New York and moved to Korea, joined Kim & Chang and take the leading roles at the Kim & Chang in arbitration practice. And second panelist I want to introduce is Naoki Iguchi. Again, one of my frequent opposing counsel, but okay, we sometimes work together as well. Naoki is the partner at Nagashima Ono, and very much specialized in international construction and the infrastructure project. So that is naturally there's a lot of big dispute coming from the construction infrastructure project. He took a very important role in different organizations. Iguchi studied at Tokyo University, quite usual, typical Japanese lawyer, and studied Stanford. And third panelist is Wendy Lin, partner at One Partnership. I'll say, yeah, Wendy was, I remember that she was a very formidable opposing counsel, one of my case, but we more often work together on the same side. And I also have experience sit as arbitrator, she involved. She's co-chair of the second time co-chair of YSIAC, the committee, and actually when you see the introduction, how the client, her client described her abilities, amazing. So I totally agree with that description. And next panelist I want to introduce is Jae-hee Seo. Jae-hee is actually working at the Allen Overy's International Arbitration in Singapore now. She was in London and Hong Kong before that. She's, I understand in the UK you call the Oxon, that means from Oxford University, and she's very active, and recently married, I would say. So congratulations. It's a very active, always have a wonderful idea on the international arbitration. Next panelist is Sachin Trikha. Sachin is now I think he's quite well known in Korea. He is quite actively involved in the various big arbitrations involving Korea. A partner at the Clifford Chance London office. Although he's physically in London, he appeared all different parts of the Asia and different part of the world in the big arbitrations. And I also understand that he's also Oxon from Oxford University and and also LSE in London. And the Anton Ware, Anton is actually we work together in many cases, and we're still working together. And Anton is a partner and the leading the office of Arnold Porter in Shanghai. He spent a long time in the DC and moved to Shanghai and taking leading role and became I noted a national leader in China now. So many congratulations. So we have wonderful panelists that we want to discuss about new ideas and proposals. So our discussion will be more like interactive, and then try to find the practical solution, how we apply in actual arbitration cases. We have a lot of discussions, particularly recent 2 years, we couldn't travel. We stuck in our office or home, and we think about how we can improve the arbitration. We have a lot of ideas we discussed before. So maybe you can focusing on the our proposal, the KCAB proposal, or like a not necessarily KCAB proposal, but proposal from Korea. We call the Gangnam Principle. The Gangnam Principle is basically we are thinking about some more effective ways to proceed arbitration, and then we're thinking about some more interactive sessions with the tribunal, and some divided the shorter hearings. All those ideas became much more possible with the introduction of these Zoom hearings or virtual hearings. So we can explore that idea first before we're dealing with the other issues. So my first topic I want to introduce is the early engagement by the tribunal. So everybody talking about it would be nice if you have early engagement by the tribunal, and is always the efficient tribunal engage at the early stage. But the problem is how we can do that. What is best way of doing that? So one of the ideas I understand is the list of issues. So may I ask the Jae-hee to start this topic?
Thank you, Bjorn-san, and hello, everyone. Very delighted to be here. So on the theme of early engagement, I actually have two sort of interlinked proposals. One is, as Kim Bjorn-san mentioned, early list of issues. The other, early tribunal questions. And they both aim at the same thing, which is to crystallize the issues of the case early. And I believe by doing so, we can make the written submission phase more efficient by letting the parties to narrow down the areas of dispute, avoiding spilling ink on non-issues or issues that are not material, and encouraging, as Kim Bjorn-san said, early tribunal engagement. So starting with the early list of issues, currently the list of issues is often adopted at near the end of the arbitral process, so at or right after the hearing. And the list is really only used for parties' final submissions, the post-hearing brief or the closing submissions. And I think in many cases, that is too late. Because this means that there is a risk of the parties' cases not really answering each other up to that point, particularly where the memorial style type of approach is adopted. And moreover, and importantly, I think during the course of the case, it's difficult for the tribunal to make interim decisions on things like bifurcation or document production that sufficiently take into account the substantive issues of the case. Because of course, if we're clear about what the issues of the case are, it's easier to decide whether some of those issues should be addressed earlier on by bifurcation, and whether the document requests actually are material and relevant to the issues of the case. So my suggestion is to bring this timing forward and adopt the list of issues as early as possible. Now, ideally, I think this could be done after the notice of arbitration and the response have been filed. But if the notice and the response do not sufficiently elaborate on the issues, then I think the list of issues can be adopted after the statement of claim and defense, but in any event, before the document production phase. And I would suggest that parties should initially seek to agree the list of issues, but to the extent that there is any uncertainties or any disagreement, the tribunal can rule on that, possibly through the case management conference if necessary. And I think the list of issues can then be updated as you go along to reflect the fact that some issues are no longer issues and the new issues arose during the course of the case. So that is what I wanted to say on the early list of issues. 변호사님, shall I go on to talk about the tribunal questions, or shall I leave that till later?
Yes, you can go ahead.
Okay, then might as well, because it is related. So the second proposal against sticking to the theme of early is early tribunal questions. Now, the current practice is that the tribunal generally asks questions again at the hearing or after the hearing. And this means, and I think some of our other panelists will talk about this as well, but there's little, if any, interaction on the substantive issues of the case between the parties and the tribunal up to this point. And then as parties, you don't receive much indication during the written submissions phase that the tribunal is actually reading and engaging with the arguments that you put forward. And they don't know what issues the tribunal actually finds to be relevant and helpful. So again, I would suggest bringing this timing forward by requiring the tribunal to ask questions or clarifications after each round of pleading. Or if they don't have questions, confirm that having read the submissions, the tribunal does not have questions at this stage. I believe that this will encourage the tribunal to engage with the party submissions as and when they're filed, and not just immediately before the hearing. And importantly, this will give some comfort to the end users of the arbitration, that are the parties, that the tribunal is indeed engaging with their arguments as they are put forward. After receiving the tribunal's questions, the parties can then clarify their case and adapt their subsequent pleadings in response to this early feedback of the tribunal. And I think this will, again, make things more efficient. So in summary, my suggestion for reducing costs, time, and frustration during the written submissions phase is to use the tools that we already have, but use them early. So early list of issues, early tribunal questions, for early clarification of issues. And that's all I wanted to say for now. Thank you.
Okay, thank you, Jae-hee. Actually, that when we attend the hearing, we are very interested in the tribunal's question in the middle of the hearing. Sometimes tribunal have no idea what he's asking, or just accidentally notice some interesting part of documents. They just ask question, then parties thought that, oh, this is an important issue to the tribunal. So I totally agree with you that is the list of issues and the early question is a good idea. Anton, I understand you also support that idea of this type of the questions, tribunal's question ideas. Do you have any particular proposal?
Yes, thank you, Kevin, and thank you, Jae-hee, for those very interesting comments and suggestions. I did want to offer my enthusiastic support for the idea of the early tribunal questions. My greatest fear as counsel is that I'm not addressing the issues that are most of concern to the tribunal. And now that I've had some opportunity, some experience to sit as arbitrator, I found that my greatest fear as arbitrator is that the parties may fail to adequately address the issues that are troubling me or that I'm struggling with. And so it seems to me that the early tribunal questions is potentially a very nice solution to both of those problems. By having the tribunal be more transparent with the parties about the particular issues and questions that it wishes to have addressed. In terms of the timing, when those questions are posed, I think we can have flexibility depending on the circumstances of any given case. In some cases, when you have an application that's made, let's say it might be an application for bifurcation or for interim measures or something of that nature, the tribunal might be able to identify at the very outset, even before the written submissions, some critical questions that it has that it hopes the parties would address in their written submissions. Another, I think, very useful moment in the case for tribunal questions is in advance of the hearing. And if it's an oral argument, that might just be a few days or a week in advance of the hearing. If we're talking about an evidentiary hearing, maybe more like 2 weeks. These are just kind of rough ideas in advance of the hearing, but for the tribunal to pose its questions at that point in time, the parties can then really focus their arguments and their presentation of evidence at the hearing in a way that addresses the issues most of concern to the tribunal. The only other point that I would make is perhaps just to preemptively address some concerns that some folks may have about the idea of the early identification of tribunal issues, and does this mean that the tribunal is prejudging the issues in some way or tipping its hand as to in which direction it's going or leaning or thinking. I think one of the ways to address that is for the tribunal to emphasize that its questions are not intended to be limiting. So these are not an exhaustive list or exclusive list of questions. This is not the only questions that the parties can address. In that sense, it's perhaps different from the function of the list of issues. But the tribunal is really just saying, in addition to whatever else you may want to address, here are some particular issues that I or we would find it helpful to have fully addressed. And I think if you give those caveats, there shouldn't be too much concern about. And you can also say, of course, that this is without prejudice to the tribunal raising questions during the hearing or after the hearing. Now that I've mentioned after the hearing, I would say that another ideal time to get tribunal questions, and one that is actually used quite often in practice, is the right after the hearing, when the tribunal has deliberated on the hearing and then poses questions that the parties can address in their post-hearing submission. So that's the current practice, and it's still a very good practice. So the early tribunal questions would not replace that; they would just be in addition to those questions. Thank you.
Thank you, Anton. Do you have any particular idea how we avoid the notion that the tribunal have a certain idea when somebody asks a question, then naturally you worry about that you have certain view on the point. I understand that there's some idea that the tribunals can discuss in advance, even during the hearing, or some particularly this type of the question and answer session. Tribunal discuss in advance and have some prepared the list of the questions, rather than just individual arbitrators ask questions. Then particularly when the chairman asks questions, everybody alert and just think about the question. So, and sometimes, I also note that some arbitrator ask, he has a question, but he is appointed by the other side. So we ask the other co-arbitrator ask that question. So what is do you have any good suggestion about that, how we organize that question?
Well, I would just offer just one or two thoughts and then invite other panelists to chime in. But I think it's important for the tribunal to simply say to the parties that, you need to understand that these questions are not intended to convey any ultimate conclusions on any issues. They're just things that I or we happen to have noticed and would like to understand better. It's not an exclusive list. We likely will think of other questions as the case proceeds. So please don't read too much into the questions. I think if you give that assurance, it's helpful a little bit. Of course, the parties may still have some concerns, but ultimately, at the end of the day, those questions are in the tribunal's mind one way or the other. So it's only a question of are they going to disclose them, or are they just going to keep them in their mind and keep the parties guessing as to what the tribunal is really thinking.
Okay, thank you.
Yeah,
Wendy.
I was just going to add that I've sat in arbitrations as arbitrator where we have been asked to go through this process of asking early tribunal questions. And it's actually, I've seen it work very well because your questions and your doubts actually do get clarified early in the process, as Anton and Jae-hee pointed out. And I think in order to not let parties think that you're prejudging, it's also important how you draft the questions and have to make them in a very open-ended way. And it'll be helpful also to break them out into factual clarifications, legal issues, and just take care in how you draft the questions to make it sound, make it open-ended. So it's not that you formed your mind, it's just a question that came to mind and you would like to seek some guidance on.
Yeah.
I agree with everything that Anton and Wendy have said. So it's about how you frame the question and how clearly you explain to the parties what the purpose of asking questions is. I just wanted to add that also, I think at the moment, questions generally ring alarm bells because they're not expected. Whereas if the question session is built into your procedural order, everyone's clear that that's going to happen at some point, then I think it would be more acceptable and it will be less scary when a question is asked, that people see that as a question rather than an attack or a prejudgment of issues.
Okay, thank you. Maybe we can move on the some of the related issues. Another early engagement by the tribunal is this interactive session and the multiple hearing idea. Because in order to have the early question and answer session or list of issues, you inevitably need some interactive sessions between the tribunal and the parties. So Wendy, do you have any particular idea how you organize it?
Yes, thank you, Kevin. What I wanted to talk about really is, it's related to what Jae-hee and Anton have been talking about, how to get the tribunal more involved early on. How do we get to see and hear from the tribunal early on and not just deal with them by way of email and correspondence, which is the usual case now. As all of you know, the usual sort of arbitration now is there is a draft PO1 that is sent to the parties. There is a case management conference that's organized to settle the PO. And then after that, generally everything gets dealt with on paper. The tribunal disappears from the sight of the parties. You don't really hear from them. Counsel are the one, drafting and being very engaged in the merits of the case. We always wonder, is the tribunal reading what we are writing? Does the tribunal have questions for us that we can actually address? And later on, the next time we see the tribunal might be the final case management conference before the evidentiary hearing. And at all these times where you see the tribunal, they're not really asking you or engaging you or the substance of the matter. It's very procedural. And the first time that you hear substantive questions from them would be at the hearing itself. And oftentimes we see ourselves scrambling then to deal with the questions. I assume the questions are good questions, right? I mean, Kevin has mentioned maybe they're not good questions, but assuming they're good questions that need to be dealt with, you'll see people scrambling to come up with new arguments, new authorities, new evidence, and a lot of these things come in very late in the day. And the worst case scenario is if it comes in at the final submission, and then it finds its way into the arbitral award, and then it gives parties grounds to set aside the award on basis that they didn't have a reasonable opportunity to deal with this new evidence and new arguments. So what can we do to try to get more hearings where we actually see and hear the tribunal and not just deal with them on paper? There are usually in the past two concerns. One is, of course, the cost of organizing hearings before the tribunal. I think that's been disposed of, largely dealt with now by Zoom and virtual hearings. It's not so much of an issue now for parties actually to organize a hearing where we can actually see the tribunal's face and hear their voices and know what they look like ahead of the actual evidentiary hearing. The second concern that parties usually have, and this builds on what Anton and Jae-hee mentioned earlier, is that, well, they're afraid of engaging with the tribunal on the substance early on in the process because they might make concessions at an early stage of the proceedings when the facts are evolving and maybe their own understanding of their client's case is also evolving. Similarly, on the tribunal's end, they might be concerned about prejudging the matter at a very early stage of the process. So what proposals do we have? One is, I think, let's try to organize more oral hearings for steps that are going to take place in any event in the course of the arbitration. So if there's a dispute over the list of issues, there can be an oral hearing organized to deal with that, because parties would then have to address the tribunal on the substance of their case. And this would give them the opportunity to educate the tribunal and also give the tribunal the chance to ask any questions it may have on the substance of the case. I also think that it would be useful for parties to consider having more oral hearings for disputes over document requests. That's something I think that Sachin might deal with subsequently, but I think it's helpful again because you would be addressing the tribunal on your case, why you require some documents to be produced, why you think the other party has failed to produce documents. Again, you'll be addressing the tribunal on the substance of the case, and you can invite questions from them. These are steps that would have to take place anyway, and you'll be writing down your client's position on paper. So I think there'll be less concerns about making concessions at the hearing with the tribunal. I think consideration should also be given to having more oral hearings for interim applications, such as bifurcation applications, which we talked about earlier. Quite often I see tribunals still like to deal with these things on paper. But if we have an oral hearing, again, there'll be an opportunity to engage them with the substance of the matter. Then the other way to address concern about prejudging, making concessions, is something that Kevin suggested to us, and I think it's a very good idea, so I'm going to throw it out there, which is to have an to make clear that the interactive session with the tribunal early on in the process, something like the Kaplan opening, but in my experience, Kaplan opening hasn't really been utilized that much because of the concerns about making concessions and prejudging. Something like that, but make it clear that it's provisional and on a without prejudice basis. So the tribunal and counsel can engage the substance of the matter, discuss each other's case, discuss questions freely and openly without fear that it's going to be cited later on in the arbitration process. Someone's going to say, my learned friend, Mr. Ware made a concession that this is not his case, but now he's changing his case, and now the client's case, things like that. If we make it clear that the interactive session is without prejudice, we're just here to discuss and help each other understand, your case, my case, and the tribunal's questions, then that may encourage people to be more willing to have these interactive sessions. Before I end off, I just want to add this, right? When Kevin suggested this to us, I did think it was a good idea. But as counsel, I think people still have the fear that even if it's without prejudice, what you say at this hearing, the tribunal will remember, and the tribunal will have that in their mind, notwithstanding that, of course, they will not make reference to it openly because it's without prejudice. So I do wonder whether there would still be resistance to using this interactive session. But I think at least it's a step in the right direction, as opposed to making it an entirely open hearing where your opposing counsel can freely cite all these concessions that you apparently made. And then parties end up arguing about whether you made a concession or you didn't make a concession, right? I'll just stop here, Kevin. Thank you.
Yeah, actually, when I proposed that without prejudice, the meeting, one of the conditions is that we shall not make a transcript. The transcript is a big issue, when you have meetings. Even the CMC now, the tribunal organized, they transcribe, and then they have you have, because it's easier for the tribunal to track what the party said. But I think it's totally undermined the purpose of that session. So when you have a frank discussion and real hot topic, it's not just like just parties. Even anybody can speak up, try to help the tribunal. And tribunal is not educated. I always describe tribunal as kind of law school students. They say that they are going to read documents. They say they read it, and then they, you don't have to repeat that. And then they're nodding and say you're explaining. Actually, they have no idea about the case. They never look at documents as soon as you finish the hearing. So this is the only opportunity you have to educate tribunal is that session, the interactive session itself. So you should have real discussion without any burden about that thing. So that is why I propose in the interview. Maybe I can hear from my Japanese colleagues, Iguchi. What's your experience about early discussion with the tribunal or the interactive sessions? Are you on mute?
Thank you, Kevin, and thank you very much for the very interesting thoughts provided by our colleagues. Well, Kevin expected that I will say something from the Japanese viewpoint, but I'd say that my mindset is almost moved to the common law mindset. So I prefer to have some common law style international arbitration rather than having some Japanese domestic court style. But let me just say something on some Japanese style, or maybe there's some common approach in the civil law jurisdiction, particularly by the domestic court. Maybe after this session, you may have a chance to refer to the Article 14 of the JCAA Interactive Arbitration Rules. JCAA, Japan Commercial Arbitration Association, is a very traditional arbitration association, but having less number of cases than any other international well-known arbitration institution. But they try to have another optional set of arbitration rules, which is an interactive arbitration rules. And then they put quite a unique clause, Article 48, tribunals active role in clarifying parties' position and ascertaining issues. And the paragraph 1 start from that was at the stage as early as possible. Well, I don't read whole paragraph in this session, but the rule requests the tribunal to take an initiative to have a meeting or hearing, whatever, to clarify the issues by meeting or asking questions to the parties, which is quite similar to what is done in the Japanese domestic court. I now most exclusively work in international arbitration rather than Japanese domestic court practice, but I did have a court hearing last week. And then I found that actually the judge did the same things as written in Article 48. So good thing for it is the judges are always read the documents submitted by the parties, so at least complaint and answers. So they raise many questions to us. And sometimes that's too much, or that's an issue to be proved by some oral evidence or some further exhibits. So I don't present everything at this first oral meeting or oral hearing, but they are taking a very proactive role in the first hearing. So my question to the international arbitration, if international arbitration adopts that kind of tribunal's proactive role in the very initial stage, how can we incentivize the tribunals to do that things? Well, Kevin said that Kevin expects that the tribunals is a law school student, so you just read the submissions and come to the meeting of the hearings and ask many questions to us. We are law school teachers, so we are maybe we are much more friendly than law school teachers and give any answers to the tribunal, and tribunal has some maybe the image in abstract what is the case would be. I think that's good, but how can we incentivize the tribunal to do that? For middle-sized claim or smaller-sized claim, I think this approach is quite efficient, useful, helpful for everybody. But for a very complicated construction, huge project dispute, parties have so many things to say and so many things to be supported by some expert opinions, quantums or engineering things. So I have a concern that for that kind of huge or big dispute, it might not be suitable to have some short sessions at the beginning. Well, going back to the common law style, so, well, I'm based on the Japanese legal qualification first, so I prefer a memorial style and to make a submission in the to get together with a witness statement or the expert report, even in the first submission round. But now I'm gradually inclined to adopt a pleading style to first make a legal argument first, followed by a witness statement or expert report. That is because in some disputes, particularly fighting against some emerging countries' government or state-owned companies, it is really difficult to frame the issues at the very beginning. So if due to the concern that the counterparty, opposing party may raise those kind of issues or may raise these kind of issues and will bear everything, that could be a waste of time, a waste of the cost for the parties or client. So initial stage is tribunal's active role in the initial stage may be good for particular type of cases and may be opted out for particular kind of some disputes. That's not the clear answer to all the questions we have, but this is my preliminary view for the interactive sessions with the tribunal at the beginning stage.
Yeah, thank you. I think it's maybe one of the ways we just give some homework. It's like a homework to students. So when the tribunal have homework, the mission to make a list of the issues at the early stage, and then we have organized a question answer session. The tribunal is supposed to ask a question. So in order to prepare the question, you have to study about the case. Also, it's quite important to when you have the tribunal secretary, or sometimes in the blind tribunal secretary is more pragmatic, somebody assisting the tribunal behind the scene. They review documents and just have any type of influence about the tribunal. In order to avoid such a things, when the tribunal engage meaning kind of actively involved in this order. That's why the oral hearing is important. And then when you have mission to make the issues and the questions, I think they have some way to persuade. Maybe it can move a bit on the different issue, but the related issue. We always dealing with document production at the early stage. People are complaining about a lot that the tribunal have no idea about document production issues of the case they decide, and just we prepare the reference schedule, long list of reference schedule. I remember that one case that we have 100 pages of reference schedule, and the tribunal make decision on every point. I don't know how the tribunal deal with that, but they decide one way or the other, and the parties complain about the issues. So we have expert on that area, Sachin. So I understand he personally dealing with this headache issues by himself. What is your proposal, Sachin?
Thank you so much, Kevin. And yes, happy to share some points and thoughts on the document production process. Before I do that, I just wanted to share one observation on Wendy's point on the early engagement with the tribunal. And this is just based on one particular experience that I had a few years ago. We were working on a case where the tribunal asked for a 2-day case management conference and invited the parties in the course of that case management conference to provide an overview of their respective cases. And I think one point that emerged from that case management conference, and this goes to the point that Wendy was making, was the ancillary benefits that I thought came out of that. Yes, the tribunal obtained a much better understanding of the case, but for us as counsel, it was a very useful process, I think, for two reasons. The first was that it made sure that we were bang on top of our own case, because the tribunal might ask any question, and that required us, therefore, to be completely on top of all the detail. And the second was that we understood our opponent's case much better by hearing them vocalize it in front of the tribunal. And the key points that they were focusing on, we understood much better as a result of that case management conference. So just an observation on the point that's just been discussed. But on document production, I would say that in the search for better practices and challenging norms, I would say the document production process must be top of the list, or at least close to the top of the list, because I think it's fair to say that it is widely seen as an overly time-consuming, overly costly, ineffective process, generally speaking. And we must do better, I think, as a community. There's a lot of fat in that process that could be trimmed. Now, where are the problems? I think, Kevin, you've already articulated one. The request to produce process, which is often documented in a Redfern schedule. Good lawyers, I think, are particularly adept at identifying a disputed factual issue and generating 10 to 15 sets of document requests arising out of it. These Redfern schedules are too long and they're too unwieldy. Another problem is the tribunal, perhaps not quite on top of the detail of the case, gripped by what I've heard called due process paranoia. If there's any doubt as to whether a request is relevant or material, let it in, and we all face the consequences as counsel. When you get to the execution process of document production, you have teams of paralegals and lawyers searching thousands and thousands of documents, trying to identify responsive material. That process, I think, is only going to get worse over time, because communication is becoming easier and easier. 10 years ago, sending an email was one thing. Nowadays, the ease of more communication is quite something. Everyone has a smartphone. Everyone is able to send emails very quickly. We are now seeing more modern, more casual forms of communication and evidence, whether that's through Kakao or WeChat or through WhatsApp or instant messaging. The volume of material is getting out of control. Once the execution process is complete, we have the inevitable complaint process, where one party is thoroughly dissatisfied with what they've received through the production process. They complain about the search terms. They complain about the inefficiency of review. They complain about you've searched the wrong pool of documents. Do it all again. And as a result, we have a tortuous procedural process of letter, application, all contested. And the costs of that are, of course, enormous. And arising out of all of this, we get a potentially a large population of documents, which you all review very carefully, but then realize that perhaps only a handful of them were actually that probative. So you've gone through this whole process. Was it worth it? Perhaps not. Could it have been done more efficiently? Almost certainly. And so what are the potential solutions? The most radical solution, I think, is that you just scrap the whole process. Now, you have some civil law jurisdictions that don't have disclosure of documents. Do they have a lesser form of justice to everyone else? As a common lawyer, I am nervous about scrapping the whole process. One always thinks that there are documents out there that can help resolve disputed factual matters. I think some form of document production process is essential. But so far as the Redfern schedule process is concerned, I think we are familiar with some of the classic techniques of word counts or page limits or things of that nature, but tapping into some of the points that have been discussed earlier, if there's an early list of issues that can really help narrow the population of requests, if there is early engagement with a tribunal, that may also help. One thing that I find quite useful is when one is formulating one's objections to Redfern requests, to elevate your individual objections into slightly more broader themes, which you can then populate in a point of principle type document or submission, where you say to the tribunal, look, at an individual level, some of these requests seem tightly defined, but when you look at them as a group, they've asked for virtually the entire universe of documents that I have. When it comes to execution, I personally am a big believer in a document production protocol, which is agreed at a relatively early stage in the arbitration, where the parties seek to agree things like ceiling of hit rates, the review process, the population of documents that you will conduct your document production over, your custodians, the metadata that you will supply, perhaps even a process for agreeing search terms if you can. If you can front load some of those issues and agree them, it becomes much harder, I think, later for a party to complain and dispute the search terms that you've used or the review process that you've gone through, and you may be able to curtail some costs. And of course, as technology advances, I remain hopeful that there will be developed some AI technology that will enable me to put a request to produce into a platform, and for that platform to produce all the responsive documents for me. But perhaps that might be a vision for 20, 30 years down the line. I'll pause there, Kevin. Thank you.
Thank you. I understand that another person that I saw quite often in the document production was actually Una. Actually, you're deeply involved in document production in many big cases. Do you have any particular suggestion?
I like the idea of getting rid of it, certainly. But I agree. I think the problem that I often face in document production is that two parties, let's say, adherence to the process is not sometimes equal. And I think that's a difficult thing to face as a counsel, because you're advising your clients in certain ways, while as it seems, and the clients feel like the other side is not really being as diligent. So that is actually, depending on the jurisdictions that you're located in, depending on the clients you're dealing with, that can become a real practical problem. So I especially like the idea of having a document production protocol and actually having an AI involved, because that gets rid of the subjective element of possibly some parties taking advantage of a different expectation and different criteria that they're using. And lessen the work for the actual humans.
Thank you. I think somebody have to develop.
Kevin, can I raise a point?
Yes,
I think the problem with red fin schedules, which I see, and why they run into hundreds of pages and hang up everyone's computers, is all the good lawyers, the good law firms, they repeat their same objections for every single category, right? I mean, relevance, confidentiality, and it's every single provision of the IBA rules. And I'm just wondering whether, in order to streamline the process, as I mentioned earlier, if there is an oral hearing, you're forced for a day of arguments before the tribunal is going to force you to say, well, group your objections, right? So these 10 categories, what are your objections? And if I decide on these, then I will deal with these 10 categories. The next 10 categories, what are your objections? You group the objections, either, force you to do it in writing, group your objections to categories of documents, as Sachin mentioned, right? Make your objections broad so that it's easier to understand, or have an oral hearing before the tribunal to deal with these things. And I think it will really help streamline the process, because I've seen so many people just making sure, as Singaporeans will say, kiasu, right? With fear of losing out, you will repeat every single objection. And that's why your column ends up running into like pages and pages. And I'm not sure that the tribunal is able to follow in that way.
Right, that's an excellent idea, actually. Okay, maybe can have some different idea. Anton, I understand that you have some good idea from the Chinese practice, so-called the evidence chart. So could you explain about that?
Sure, thank you, Kevin. As American lawyers, we often are criticized for approaching every case as an exercise in comparative storytelling. So the claimant frames its case in the form of a particular narrative, and then the respondent develops a competing narrative. And then you have the parties expending a whole lot of effort trying to shape and frame the evidence in a way that will fit each party's particular narrative. Now, for many American lawyers, and I would include myself, I think we would happily plead guilty to this charge. We tend to think that arbitrators process information best when it's presented in the form of a coherent and credible story. And the storytelling also helps to bring the evidence to life and to put everything into context. But that said, there are definitely some weaknesses to this competitive storytelling approach. And one of the weaknesses is that it can become a very expensive exercise. You end up developing these very lengthy and very complex written submissions, particularly in the memorial style written submissions. You develop lengthy witness statements, which are also crafted to support the development of this narrative, this telling of this story. But there are many cases, I think, where it really just isn't necessary to build a story around the evidence. For smaller cases or cases where the legal and factual issues are relatively straightforward, I think what the arbitrators need most after reviewing the initial pleadings is to simply see the evidence. So the question is, how can we present the evidence to the arbitrators without packaging it in these lengthy written submissions, or even without using witness statements? And having lived in China for the past 5 years, I've had the opportunity to observe Chinese arbitration procedure. And in a typical Chinese arbitration, each party will summarize its documentary evidence in a simple evidence chart, which sets forth for each exhibit the presenting party's basis for contending that the exhibit is authentic, the exhibit's relevance to the case, and the purpose for which the presenting party is submitting the evidence. Now, what's interesting is that this summary of evidence is not in addition to the written submissions and witness statements. It's generally in lieu of such submissions or statements. Now, in Chinese practice, the opposing party would then prepare a separate chart that sets forth its responsive position as to the authenticity, relevance, and purpose of each of the other side's exhibits. And it strikes me that, consistent with the Redfern schedule practice, although we've heard quite a bit of criticism of the Redfern schedule practice here today, we could combine those two charts into a single chart. So ultimately, you would have only two charts in total. So one setting forth the parties' respective positions on the claimant's exhibits, and the other chart setting forth the parties' respective positions on the respondent's exhibits. And if you wanted, you could arrange the exhibits in chronological order as opposed to exhibit number order. Now, I found that going through this exercise of carefully examining each of your own exhibits and each of the other side's exhibits is very useful. And it's also consistent in any event with how I like to prepare for an evidentiary hearing, by really engaging, by kind of putting aside the briefs and the narrative and really focusing on the evidence. So what I would suggest is that in international arbitration cases outside of China, particularly smaller cases, that parties and tribunals can consider adopting an evidence chart approach as an alternative to lengthier written submissions, and potentially also as an alternative to witness statements.
Okay, thank you, Anton. It's quite interesting, and I think it's quite good idea, particularly in a medium and small size case. Could you also do you have any insight from, not necessarily Japan, but it's from your personal experience?
Well, thank you, Kevin. So I'd like to say two things. One thing is, just off the top of my head, so we talked about some initial proactive role of the tribunals, but how about setting a very short oral pleadings or oral presentation right after the submission of the first stage and before the tribunal decisions on the document disclosure? Because I think somebody had already referred to that. We arbitration practitioners' concern on the document disclosure is, since in the traditional style, the tribunal has never read through whole submissions or exhibits attached to those submissions, and then the party make a lengthy list of the document disclosure, and the tribunals will have to decide whether or not the document is relevant or not in a very short period, saying that's 2 weeks or 3 weeks. So how about make some 2-hour or 3-hour presentation by each party before tribunals go into the decision of the document disclosure. And the second thing is just a question to Anton. You said that evidence chart in the Chinese practice style. So is that evidence chart provides how much description of each of the exhibit? So it's a 1 paragraph or 2 paragraph. Well, I think that Korea and Japan would have the same kind of some evidence chart in the court practice. Actually, we do for the 1 paragraph explanation of the purpose and the point of the evidence exhibit in an exhibit chart. So.
Yes, thank you. That's an excellent question, and it's something I omitted to mention, but it's an important point. I think that the Chinese arbitration practice sounds to me quite similar to the court practice that you mentioned. It's very streamlined, so it could be contained in a single paragraph or at most a couple of paragraphs, but it's very succinct, and so the chart does not end up running to hundreds of pages. Of course, it depends on how many exhibits that you have, but it is very straightforward, succinct, and to the point.
Yeah, actually, when you did this event, when you visit the event site, you see that the locations program on the schedule or different things. You can some guide about the documents in the what area you want to go into. I'm thinking about just like, because we have now technology, we have a brief description of the evidence and just the key point that the document shows. When you click the documents, the parties can add the description like a bubble or some other way to explain this relevant part means something or related to other arguments. Could be quite efficient to understand documents in a better way, because nowadays we see the documents on the screen quite often, and then we should use that utility of the screen, but we actually do not use very much on this arbitration yet. I think that the evidence chart idea is quite useful, and then the good practice always, big law firms, we always prepare such a things for the attorney's purpose anyway. So somebody prepare documents and summarize evidence in a very, very careful way to assist a senior person, and then that never shared with tribunal. I think maybe we can share that evidence, that chart with the tribunal. That'd be excellent.
So this is what, Kevin, you're always looking at when we see you in arbitrations. This chart that someone prepared for you.
All right. Maybe you can think about to be further about the after hearing. We have nowadays the post hearing brief, quite popular. Actually, when I started my arbitration practice, normally we have 1-day hearing, in-person hearing at the beginning of the arbitration. Explain the case and we make the arguments in person, and then we have the hearing and we have oral closing at the hearing. So we prepare at the end of the hearing. But what I see nowadays is actually that case management conference is all become the conference call. Nowadays a video, and without introduction of case, actually just talking about schedule. And then you have hearing. In the course of the hearing, we are very surprised that tribunal have that thought. They are not interested in the point that we vigorously argued before. And then you have the post-hearing brief. Normally 2 rounds post-hearing brief. And another recent trend, I would say, is oral closing. So 2 rounds of submission and the oral closing. That the party is not that happy with, I would say. So we have to find a way how we effectively proceed this post-hearing event, I would say. So I think this is proposed by Una, right?
Yes. Although I think you might not be happy with my proposal, because what I'm proposing is that actually a two-tiered hearing system with 2 rounds of submission. But it's in the tradition of what the others were saying, which I wholeheartedly agree with. This is in order to increase the interaction between the tribunal and the parties. And I think a lot of the ideas that were discussed, like the updated list of issues, tribunal's early questions, and their updates on the issues list, I would consider those all as prerequisites for the success of the entirety of the proceedings, as well as the 2-tiered hearing system that I'm discussing. But to put it simply, the proposal is taking the concept of the oral closing that we sometimes have and making that part of the hearing structure as the second hearing, and having the 2 rounds of final written submissions to assist that process. First, there would be the regular merits hearing as we are used to it, with each party's presentations on law and fact and testimonies from all of the witnesses and experts. Then the parties would submit their first post-hearing brief, but structured to summarize the evidence and arguments based on the latest issues list. So after the submissions, the parties and the tribunal can gather and have a very short second hearing with counsel only to go through the issues list and answer the questions from the tribunal. And so finally, the second post-hearing would be submitted to address these questions that came up during the second hearing. And I realize this is not an earth-shattering concept, as multiple hearings are already utilized in various forms in arbitration, especially in complex cases like construction disputes or in bifurcated forms and whatnot. The proposal here is to standardize that practice at the most basic level in a 2-tiered format, but in a way that is geared to first letting the parties run the hearings as they see fit, and thereafter to narrow down the proceeding to focus on the issues that the tribunal really wants to listen to. The first hearing is clearly the evidentiary hearing, so maybe the second hearing can be called an analytical hearing. And this is so that, because sometimes at the end of the day, when you get the award, you are surprised that there seemed to have been a gap in between what the tribunal thought was important, what the parties thought was important. So in this way, what I think this would guarantee is that there is at least no mismatch in what the parties in the tribunal consider to be the material issues, and no regrets that those issues had not been fully briefed and considered. Now, but I guess people might ask, why can't we just do that with the first hearing and have a post-hearing brief structured by the issues? The reason I'm saying this is because I think you would be losing a chance to get real valuable feedback from the tribunal. So this is about having a balance between, on the one hand, letting the parties run their cases the way they want to, and 2, customizing your advocacy to address the concerns that the tribunal really has on your case. And the first purpose is, I think, important because while the updated issues list will be tremendously helpful in understanding what the tribunal's concerns are, still you don't really know necessarily what the tribunal may feel after the hearing, because that is still evidentiary in nature. You don't know what your side or the other side's witnesses or experts may admit and what new facts may come to light. And strategically, different counsel do have differing approaches on running the most effective hearing. And the parties should thus first be free to run the best case as they see fit. In order to achieve the second purpose, to understand what the tribunal is focused on, I think we need a streamlined process to make sense of all the evidence and arguments and discussed. So we also need to be able to encourage the tribunal, or sometimes even twist their arms a little bit, to speak up on where they feel the parties are still weak and still have not proven their case. Well, I guess you could also say that the tribunal can ask questions before the first hearing or send a list of questions or issues afterwards, so that parties can address this in the post-hearing brief. Yes and no. I think this is because, I mean, the tribunals are, of course, always free to do so, and sometimes they do, but in my experience, more often than not, they don't. And even when they do, it's probably not enough, and we miss getting the detailed questions, the little concerns they might have, all of which they might not feel comfortable putting down on paper, but which could add up to a bad result. So in order to have this final productive feedback session with the tribunal, we need to first give the tribunal time to digest the avalanche of material that is coming at them at the first hearing. And there is a limit to human capacity and how much information can be handled all at once and made sense out of. And psychologically, many people won't feel comfortable asking questions on the spot if they don't feel like they have a good grasp of the information presented, especially as they know their questions will be closely scrutinized. And I think the tribunal will also appreciate having a less formal and a safe environment to ask questions rather than putting everything in writing. And having a back and forth discussion is, of course, something you can't really do in writing. But again, having a tight structure of the second hearing, I think, is key, so that you can actually focus on issue by issue matters rather than having the parties repeat what they think to be the strongest points for them. And as for the post-hearing briefs, I think I personally don't like to write 2 rounds of post-hearing briefs. And I think in the smaller cases, of course, you won't have to. But overall, I don't think it is overkill to have 2 rounds of post-hearing submissions. I think the final round of submissions are the most important, and practically the ones that the tribunal will pay the most attention to, as they will be organized by issues, making it easier for the tribunal to compare them side by side. And the second post-hearing brief will hopefully contain the parties' last words on the issues that the tribunal had raised. And these will be the most helpful for the tribunal in writing the award. So rather than focus on heavy written submissions during the early phase of the hearing, which I actually think we can go lighter on, I think it is more important for the parties to place more emphasis on the briefs that follow the hearing. Thank you. I don't know if you're happy with that, but that was my
Thank you. Actually, we have just a few minutes left. Actually, one of the idea I would propose in that connection, actually, after hearing, we have to expedite everything, posting brief and together with deliberation and preparing the word, because it takes a long time. My idea is that just maybe tribunal start drafting of a word just after hearing, while the parties preparing the posting brief. And the tribunal can distribute the draft, a word without conclusion part. Just summarize parties' position and the issues they want to deal with in the word. Because nowadays I see that whatever the conclusion be by the tribunal, tribunal always introduce the parties' position because that is institution's practice. You need to introduce the parties' position on each issue, and then the tribunal's finding follow that. So why don't you just start drafting the word together with the posting brief, and then the oral closing things, and then the tribunal will be ready to decide, and then put their conclusion, and then ready to issue the word immediately. And then the tribunal also have incentive, and they are in a position to know what is missing in the word, or what is the problem, how they come to the conclusion. So we just work together as soon as we finish the hearing, tribunal and the parties work together, and they just say that 4 weeks might be sufficient to the parties to make a posting brief. All the associates are looking at the partners, and the tribunal say 4 weeks might be good enough, and everybody angry about holiday things. Okay, everybody commit to the case, and then we can finish all the case together. We can just finish everything together quite quickly and in interactive way. So when you start to the list of issues at the beginning, we update the list of issues, and with the list of issues, we can draft the word and just let the parties just add the parties' position in the word. Maybe even without the posting brief, the parties can update their parties' position in the draft word with the key documents, key evidence they want to introduce. Then the tribunal added that the conclusion part with the parties have no complaint about it, just about express of their position, and also they have no way to miss any point, important point in parties argue as some this is a totally new idea, but I want to share with you. But one way to expedite. Okay, I think our time is up. We have very interesting discussion. I expect you guys are all good and lots of ideas, but I'm very pleased and delighted to hear the wonderful ideas all from you. And we can the reason why we actually organize this session is that we want to have more clear idea, the more specific proposal, make the arbitration more efficient. And then we just develop that idea into more in a written form, as we did in the SOL protocol, and then we just apply that practice in actual practice in the international arbitration in the future. So thank you very much again for joining us. We continue to discuss these matters in a personal level after break, maybe during the break. Thank you. Thank you very much.
Thank you, everyone, for the amazing discussion. Just before we close, if we could take a group photo just briefly. So I'll count to 3. So 3, 2, 1. Okay, great. Thank you so much.
Thank you.
Thank you.
Thank
Thank
you.
you. Goodbye.
Thank you. Bye. It
Bye.
was great fun.
Thank you.
Everyone, we've now come to an end to day 1 of the 10th Asia Pacific ADR Virtual Conference. We would like to thank all participants for your time and support. Today has been a valuable time for our ADR community. We promise you there will be further interesting topics tomorrow, so please join us again at 4 p.m. Korean Standard Time. Please also note that an online networking session beginning immediately after this is available. So to anyone interested to join us and chat with us, please refer to the chat box for further details. Once again, thank you all for joining us, and I hope to see you tomorrow. Goodbye.